Senior Assistant Public Defender, working on behalf of Ms. Murdoch. Would you please state your name, ma'am?
Nicole Murdoch. Sorry, Your Honor, I didn't know I was supposed to be here. I would have been here a long time ago.
I do have a plea form, but we have a progress report. Have you seen it?
Yes, Your Honor, I'm prepared to address it. Your Honor, in terms of the progress report, as you can see, if you would like, I will focus in on the mist as well as the opiate, just so that you'll have the whole picture. When Ms. Murdoch was released from the jail,
What you're about to see is a courtroom
regardless of the reason, she's taking medication
turns into a serious legal
that
Nicole Murdoch stands
she would not do that day in life.
positive for opioids while under supervision.
I had no idea.
Now she's trying to explain how it happened.
Will not do that again.
Her defense,
Never in life,
she didn't
I
know
promise
she
you.
take an opiate.
As God is my
Instead,
witness.
she says a coworker gave her medication for
good enough.
and she had no idea what it
Your Honor, would it be
But
okay
in
if
court,
she,
intent doesn't always matter as much as responsibility.
if she drug
The
tested
big
today for
question
you?
here is simple.
I'll do
Should the
every
court
day for
believe
you.
that
And I do believe she
explanation
tested
or hold her
yesterday and it was
accountable
negative.
And
anyway?
Friday.
Because as you'll see, the
Every
judge
day I'll go
isn't
for you.
entirely convinced.
Every single day.
She immediately went over to community corrections. She did not know that she would need $12 for her testing, and she did not have that with her. So she came back the very next day and tested, and you'll see those two. There's the missed day. Oh, sorry.
And then the negative.
You'll see there's the missed day, and then the day she came back. And then she stated that there was one other day that is missed, where she was unable to make a payment. Ms. Murdoch indicates, and she is also on, I think
it's where you blow twice
on the
a day.
sober league, where
Yes.
she blows twice a day. She is indicating that she was very surprised when she learned of the positive for opioids. She states that she had been at work and had been in having some
Menstrual cramps. I'm actually on the verge of getting a hysterectomy because of them.
And because of that, she had gotten some pain medicine from a colleague. She did not know that it was an opiate. She had no idea. She is willing to test today, and she indicates that she does not use marijuana. She has not had any positive sober link, and she is willing to test twice a week if that would make Your Honor feel more comfortable with her out in the community. But she is very adamant that she was not aware that she was given anything that was an opiate or that would test like an opiate.
I swear to God, I don't do drugs, Mr. Simpson. I'm almost 50 years old. I work from 6 p.m. to 6 a.m. every day. When I'm not asleep, I'm a full-time out there. If I had known that, I would have never took it. Very big mistake, definitely.
Well,
here's an important
to
legal
show you that I
detail
don't
often
do
gets
drugs.
overlooked in probation or bond conditions. Compliance is strict. Even something that might seem minor, like missing a scheduled drug test or taking medication you didn't verify, can trigger serious consequences. From the court's perspective, individuals under supervision are expected to verify every substance they take, even over-the-counter medications. That's because the court has to protect the integrity of the monitoring system. So while Murdoch claims this was simply a mistake, the judge has to decide whether the explanation is credible or whether it represents a violation serious enough to justify jail time. What do you think? Should an honest mistake count as a violation?
Regardless of the reason, she's taking medication that she should be taking.
I would
She
never
would not do that
day in life.
It comes back positive as opiates.
I had no idea.
She will not do that again.
Never in life, I promise you. As God is my witness.
Not good enough.
Your Honor, would it be okay
Go ahead.
if she drug tested today for you?
I'll do every day for you.
And I do believe she tested yesterday and it was negative.
And Friday. Every day I'll go for you. every single day, I promise, to show you that I don't do.
Counsel approach.
I can't, if he gives me a minute, I don't have nobody. It's just me and my baby. My brother lives way in Flint. And turn myself in for how long? Sure, I'll have to get, yes, I'll come back to.
Your Honor, I would just like to state again that she is very apologetic, that she should not, she knows that she should not have taken medication, and she did not, but she did not realize that it was an opiate.
I did not.
She just thought it was regular medication.
Your Honor,
If Your Honor is going to incarcerate her, we would ask that she have the opportunity to make arrangements for her son. She has a brother who lives in Flint that she can get in touch with and hopefully get her son there tonight, and she will report to the Washington County Jail by 8 a.m. tomorrow morning.
I came as soon as you asked me today.
She is willing to testify.
For sure.
I'll adjourn her probable cause conference to the 12th, March 12th at 9 a.m. I'll give her a chance to get arrangements to take care of her child. So I'll indicate that I'll continue her bond at this point in time. Defendant is to report to the Washington County Jail with ID at 8 a.m. tomorrow morning. Understood?
Yes, sir.
At which point then her bond will be revoked.
Sir, do you know how long I should advise my brother?
This moment right here
State
is where the
again that
tension
she
in the courtroom
is very
really
apologetic.
peaks. Murdoch
she
is clearly emotional, insisting
should
she
not-
had
she
no idea
knows
the
that she should
medication
not
contained
have
an opioid.
taken
She even offers
medication
to
and
test
she did not,
every
but she
single
did not
day
realize
to
that it
prove
was
she doesn't
an
use
opiate.
I did not.
But here's
She
the
just thought it
difficult
was regular
Judges hear
medication.
explanations
Your
like
Honor,
this
If
all
Your
the time.
Honor
Some are genuine mistakes, while
going
others are
to
attempts to avoid
incarcerate her,
consequences.
we would ask
That's why the
that
judge
she have the
responds
opportunity
bluntly,
to
because
make
ultimately,
arrangements for
the
her son.
responsibility
She
falls
has
on
a
the
brother who
defendant
lives
to
in
make
Flint
sure
that
they
she
follow
can
every
get in
condition
touch
of her
with and
release.
hopefully
So the real
get her
dilemma
son there
becomes
tonight,
this.
and she will
Is this a
report
sincere
to
mistake
the
or a
Washington
violation the
County
court
Jail
can't overlook?
by 8.
Or my son?
At least a week.
Okay. Thank you. I'm sorry, Your Honor. I do apologize for anything.
Thank you.
Court calls the case, People versus Jennifer Bishop.
Alexander, on behalf of the people, Your Honor.
Jordan, please state your name for the court.
Ethan Jordan.
All right. I have before me a plea form indicates that he would be pleading guilty to an added count of attempted resisting and obstructing a police officer. That's a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. Defendant is also agreeing to write a letter of apology to the victims, and also there is an agreement to sentencing under HIDA. That's the court's full understanding of the agreement.
That's correct, Your Honor.
And that is correct statement.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Ethan Jordan.
Sir, it is this court's understanding that you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
I do.
Still wish to, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Gar would in the 15th District Court. You understand that?
Understood.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I have.
Any question regarding those rights?
Yes, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights. Are part of a trial. You understand by pleading guilty, You'll be giving up those rights as well as all the rights on that form.
Understood.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am.
Were you on probation or parole at the time of this offense?
I was.
Both? Well, not
Probation.
both. You were on probation? Out of what court?
15th district.
You understand that your entry or plea in this case could be a violation of that probation?
I do.
You understand that as such, that court could sentence you to the maximum allowable under that other charge?
I do.
And understanding that, you still wish to plead guilty to this charge?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily?
I am.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
November 29, 2025, at the location of 1201 South Main Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you come into contact with a police officer from the University of Michigan Department of Public Safety?
Yes, Your Honor.
And what happened?
I was denied entry into the stadium based off an invalid ticket, and
You were denied entry into the stadium without a ticket.
an invalid ticket, but yes. I resisted a not campus security, stadium security officer, and then after which police officers came to assist in removing me from the stadium, and it was at that point where
So you went to the stadium and you just decided you'd go without a ticket?
I was kind of like scammed out of a ticket.
You were scammed out of the ticket?
I purchased a ticket that was invalid.
Oh,
So
you're still going to go anyway.
no, that wasn't the intent to.
Mr. Jordan, you were denied entry into the stadium, correct? And security tried to get you to leave
Correct.
and escort you out,
Correct.
and you resisted that attempt.
Correct.
And then UVM police officers, uniformed, approached, and they attempted to assist the security and
Yes.
escort you out, and you continued to resist.
Yes.
And you realized they were giving you lawful commands to leave the stadium.
Eventually, I did. Yes.
Did you realize?
Well, no, you eventually left, but you realized that at the time they were giving you the order or attempting to try to get you to leave the stadium, that they were giving you a lawful command to leave the stadium.
Yes.
You understand that between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
We're satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 50th District Court. Probation sentencing in this matter will be
March 31st at 9 a.m.
March 31st, 2026, 9 a.m. before Judge Gar. Bond will continue.
Very good.
Thank you.
Thank you very much, Your Honor. Have a good day.
Thank you.
All right. Record should reflect we had a bench conference in this case. Really, there's a motion by the people to modify his bond.
And that's correct, Your Honor. It's our understanding that this case was picked up while the defendant was on bond for another case involving controlled substance delivery manufacturing as well as probation in circuit court. And I believe per the statute, he should have been given an surety bond. So this time I would be re-requesting our original request of $50,000 cash. However, I understand the court. Thank you.
And Your Honor, we do understand the people's concern as well as what the statute states. However, my client has been out on bond on this case with absolutely no issues. We know that there is another case. He was present for his preliminary examination on Tuesday for that matter. I believe that the issue of bond was addressed at that time and the judge put him on a home confinement tether GPS. That was Tuesday. He does have that tether on to my understanding. Yes, there may be a violation. It has yet to come up in circuit court as of now. However, he's been doing everything he's supposed to do on bond, Your Honor. So I'm asking that the court, if there is a requirement to put some type of cash component, make it as minimal as possible to allow my client to continue complying as he's been doing.
All right. I would find that the setting of personal recognizance bond under the circumstances with use of discretion by the magistrate. Set his bond. I am going to take into account the fact that, yes, it should be some type of surety bond, but I'm taking into account that, as defense has indicated, he's been doing what he's supposed to be doing, other than picking up this case while he was on bond on the other side. But since that point, he's been cooperative, he's been doing everything. So I'm not going to require what the people had requested, and not necessarily a surety bond, but I'd be looking at it this way. I'm going to set his bond at a 10% bond in this matter, at least that way he can post it. I will also set the, you want this set for preliminary?
Yes, Your Honor, please.
And your discovery is complete?
To our knowledge, Judge.
All right, discovery being complete. Would the people have their witnesses available the 17th?
Double check on the. We are just waiting on the 911 call.
Pardon?
Requested the 911 call, but I have not received it yet.
Okay.
We're fine, proceed.
You're willing to proceed?
That's right, Your Honor.
All right. Preliminary examination in person, March 17th, 2026. 9 a.m. before Judge Moore. All right. I'll set his bond. Defendant is remanded.
Thank you, Judge.
Thank you. Versus Theophilus Smith, 2 cases.
They're representing Mr. Smith.
Theophilus Smith.
Thank you. What are we doing?
Your Honor, we are continuing negotiations in terms of hopefully coming to a resolution very quickly. We are asking for a 1-week adjournment. Perhaps we should approach, if we could, please.
You want 1 week?
Yes, if so. I am standing in for Mr. Bellinger, and Mr. Bellinger and Mr. Childs have been in ongoing conversations, and my understanding is that they may be close to a resolution that possibly could have been handled had Mr. Bellinger been here today.
March 12, 2026, 9 a.m. Bond continue.
And may I please speak on bond?
Go ahead.
Mr. Smith is requesting that the court allow him to be released to his mother's home in Canton. He indicates that he will continue to receive community mental health services, that he will return for all future court dates.
I'm not going to change his bond at this point. He's a week out. Let's see if there's a resolution on it.
This courtroom session highlights several important legal realities.
I came as soon as you asked me
insisted the
today.
opioid test result was an accident, claiming she unknowingly took medication given by coworker. But in the eyes of the court, accountability under supervision is strict,
For sure.
and even unintended mistakes can carry serious consequences. The judge ultimately allowed her time to arrange care for her child, but still ordered her to report to jail the following morning. A reminder that
Adjourn
courts
her
must
probable
balance
cause
compassion
conference to
with enforcement of the
the
law.
12th,
Now we want to hear from
March
you.
12th.
Do you think the judge
At
made
9
the right
a.m.
call here, or should
Give her a
Murdoch be
chance to
given
go
another
get it
chance?
to
If you found this case as intense as we did,
get
make
arranged
sure to
to
hit
take
that
care
like
of her
button,
child. So
share
I'll
your thoughts and
indicate
comments,
that I'll
and don't
continue her
forget to
bond at this
subscribe
point
for
in
more
time.
jaw-dropping
Defendant
courtroom
is to report
breakdowns.
to the Washington. And if there's a whole thing put together and I have more information about where he would be, then I may not have a problem releasing you at that point. But I'm not going to change anything now.
All right.
All right.
All right. Thank you.
Thank you. Okay. Does call the case of people versus Olin Thurman.
Alexander, on behalf of the people, Your Honor.
And Senior Assistant Public Defender with and on behalf of Mr. Thurman. Would you state your name?
Olin Thurman.
Thank you. What are we doing
Your Honor, we are requesting a preliminary examination on,
on both cases?
that is correct, Your Honor.
Discovery is complete.
That is my understanding.
People have their witnesses available the 17th.
We'll do our best, Your Honor.
Preliminary examination in person, March 17th, 2026, 9 a.m. before
Judge Gar.
Judge Moore.
Your Honor, if I could address bond.
Yes.
The defendant has made 2 complete calls to the victim since being arraigned, one on 2/27 at 4:12 p.m., which I believe would be well after he was arraigned, and one on 2/28. He also has 8 attempts to contact her number that were not answered as recently as March 3rd. So at this point, I'm going to be asking that phone and text privileges be revoked.
Any response?
At this time, Your Honor, we have no response.
Defendant's phone and text privileges are hereby revoked. Texting privileges are hereby